The statement "what is in writing shall only be proved by the writing itself" expresses the best evidence rule, which is embodied in the Bharatiya Sakshya Adhiniyam 2023. According to this rule, when the terms of a contract, grant, disposition of property, or any matter required by law to be reduced into writing have been recorded in a document, the contents of that document must be proved by producing the document itself. The rule is based on the principle that written documents are more reliable than human memory. A written record provides the best and most accurate evidence of its contents, meaning of the rule when a transaction has been reduced to writing, oral statements cannot normally be used to prove its contents. The document itself must be produced before the court. Illustration: A and B enter into a written agreement for the sale of a house for 2000,000. If a dispute arises regarding the price, A cannot simply say in court, "The agreement mentioned 20 lakhs rupees." The written agreement itself must be produced because it is the best evidence of its contents. Reasons for the rule: it prevents fraud and false claims. It avoids mistakes arising from faulty memory. It ensures certainty in legal transactions. It gives preference to more reliable evidence. Oral evidence cannot contradict written documents. Once the terms of a transaction are proved by a written document, the parties generally cannot lead oral evidence to contradict, vary, add to, or subtract from its terms. Example: a written lease states that rent is 10,000 rupee per month. One party cannot later claim through oral evidence that the agreed rent was 15,000 rupee per month. The written document will prevail. Exceptions to the rule: although the rule is important, the law recognizes several exceptions where oral evidence may be admitted. 1. Fraud, coercion, intimidation or misrepresentation. Oral evidence may be given to show that the document was obtained through fraud, coercion, undue influence, intimidation, misrepresent. 2. Separate oral agreement on a matter not mentioned in the document. Oral evidence may be admitted regarding a separate agreement concerning a matter on which the document is silent. 3. Condition precedent. Oral evidence may be given to show that the document was not to become effective until the happening of a certain event. 4. Subsequent oral agreement. In certain cases, parties may prove a later oral agreement that modified or rescinded the earlier contract, provided the law does not require such modification to be in writing. 5. Usage or custom. Oral evidence may be admitted to explain trade usage, local custom, or technical expressions used in the document. 6. Facts showing how the language of the document relates to existing facts. When the language of a document is unclear or applies imperfectly to existing facts, oral evidence may be given to explain its meaning. Simple case study. Ramesh sells his land to Mohan through a registered sale deed mentioning a price of 10 lakhs rupees. Later, Mohan claims that the real price was 12 lakhs rupees and seeks to prove this by oral testimony. The court will reject such oral evidence because the written sale deed is the best evidence of the agreed price. However, if Ramesh alleges that his signature was obtained through fraud, he may produce oral evidence to prove the fraud. This falls within a recognized exception. Conclusion. The rule that what is in writing shall only be proved by the writing itself is a fundamental principle of evidence law. It requires the production of the document itself to prove its contents and generally excludes oral evidence that contradicts or varies written terms. The rule promotes certainty, accuracy, and reliability in legal transactions. However, exceptions exist in cases involving fraud, coercion, separate oral agreements, conditions precedent, subsequent modifications, customs, and clarification of ambiguous language.